Exponential Consult. I approached a long-time friend, Dr. Oyewumi of Center for Law and Business, and appointed him as company secretary, appointed their firm as company secretary. And we gathered together an eminent board of directors and told partner CLB, please could you call for a board meeting next Monday? And I was told, no, you have to give notice to call a board meeting. And I said, this wahala of Cama is too much for me. I really need to sit down and learn about it. So today, I don't want you, the participants, to go through the kind of University of Hard Knocks, which I had to go through without matriculation, no graduation. So my long-term friend, Mr. Dr. Oyewumi of Center for Law and Business, and I are partnering to bring this to you so that you can be compliant and learn all that we need to know about the revisions, the latest so then we can run with it. I hope I've been audible so far. I'll just go on with the slides. Cama 2020, understanding the implications for entrepreneurs and businesses. I have introduced myself, a pharmacist and now a management consultant. We love to build people with skills and entrepreneurial abilities. I am so privileged to be here, and we are welcoming other partners like the speaker. Our first speaker will be AG Abubakar. He's the Registrar General of Corporate Affairs Commission, and he will be represented by Mr. Tolulope Adeola Sonaike. Our second speaker for the day, we have Mr. Dapo Oye. Nike Adeyemi of Faith Foundation. She will be joining us to also speak. She is already here, actually. And keep your microphone muted at all times, except when you're requested to speak. If there are any tech issues, please put that in the chat box. In addition, we'll be taking your questions in the chat box. Kindly participate in all the polls to let us know how we're doing. This session is also being transmitted live to YouTube, and the address is the youtube.com Center for Law and Business. I think we'll take a break right now while I invite one of our speakers, Mr. Tolulope Adeola Sonaike. So I'd like to know, is Mr. Sonaike with us? Hello? Mr. Tolulope Adeola Sonaike will be representing AG Abubakar, Registrar General Corporate Affairs Commission. Mr. Sonaike, have you been unmuted, please?
Yes, I have. Good afternoon.
Good afternoon, and thank you for being here. We are looking forward to hear all you would tell us. May I just take a few minutes to highlight parts of your profile? Mr. Tolulope Adeola Sonaike is a lawyer and presently the Assistant Director, Post Incorporation in the Registry Department at the Corporate Affairs Commission, Head Office in Abuja. He has served several capacities. Some include Secretary, Harmonization, Legal Enforcement Subcommittee of the Financial Services Regulation Coordinating Committee. He's been at the head office in Abeokuta, served as Secretary, Management Committee of the Commission. He's been at the head office and at Alausa and again at Lagos Island. He's been a member of the Senate Technical Advisory Committee on review of the Companies and Allied Matters Act, Cama, as well as the Investments and Securities Act, ISA. Join me in welcoming Mr. Tolulope Sonaike. you can please share your screen. I'll stop this right away. You're very welcome, sir.
Thank you very much. Good afternoon to all participants. Let me first register the Registrar General's apologies. He would have wished to be here, but at the moment he's also addressing some other group. As we all know, this is an issue on the front burner now. So there are many groups and platforms who want us to share, who want to talk about it. So it's about now addressing another group. But you are assured of the regard of his ISS team. Having said that, let's quickly just talk about, I have only 15 minutes from what I understand. So
That's right.
Right, I'm going to rush this and highlight the main issues. I'm also hoping that during the questions and answer session, we can address some other issues that will surface. Now, the objectives of the new law, the Act Cama 2020, there are 5. The first one is to ease the starting and growing of business in Nigeria. And the other one is to ensure more appropriate regulation for micro, small, and medium scale enterprises. So you find that most of the innovations in the law will focus on small companies and reduce the threshold for their operations in the system and even entry barriers. Now, the third one is to enhance transparency and shareholder engagement. It is also to align regulatory framework with international best practice for competitiveness and so enhance the efficiency of the regulatory process. And finally, as in the global context, it is to make Nigeria an investment destination by attracting, retaining, and growing investments. Having said that, let's quickly consider some of the new things that you find in the Act. Let me say here that if you take time to read through, it's a very huge material. It's the largest piece of legislation in Nigeria. It's always been, Cama had always been. And now we have a new law that has about 257 more sections added to what existed, 613 sections. So you imagine how big it is. You'll find more than 200 new things in the Cama. Now, the first thing that we should note is that we have expanded the composition of the board of the Commission to include a representative of the medium small enterprise association. And the reason for that is so that we can have the benefit of their input at the level of policy formulation. And this will help promote, enhance the regulatory environment and promote growth of these businesses in Nigeria. The other thing you may want to note is that we have also introduced pre-action notice so that we don't have to, people who have grievances against the Commission don't have to rush to the court every time. It's distracting us, it's costing us a lot of money. And some of these issues are issues that we can actually settle out of court. So if we have such notices, we can quickly resolve issues and move forward. Then what interests most people is the introduction of the one shareholder company. The one shareholder company. And somebody has asked, what is the difference between this and what we have in business name, what we call enterprise? Now, the major difference is that the one shareholder company enjoys all the privileges of a corporate body that companies generally enjoy. It has a corporate personality, legal personality. It can sue and can be sued in its name. It can hold property, and it has perpetual succession. Now, somebody has also raised the concern that when the single shareholder dies, how does the company continue? But again, we'll have to understand that this is a separate entity, a legal entity, a person in law, separate from its promoters and its managers. So just the same way shares are treated as personal property, of course regulated by provisions of the articles, the same way succession will be treated in this case. It will be left for the successors in title, the administrators, whoever is inheriting or taking the properties from the deceased, to determine what he wants to do with the company, whether he wants to continue to run the company or whether he wants to wind it down. Now, another thing of interest is there was a time where people were talking about removal of the consent of the Attorney General. Now, let's clarify this. The consent of the Attorney General is in this Act. It's still retained. The only difference is that it has a timeline for responding to applications for consent. Now, that timeline is 30 days, and that will start to count from the last day he receives the final information he needs on that application. The new law has also abolished what we used to know as authorized share capital. What it has introduced in its stead, it's minimum issued share capital. So what this has also done is to reduce the cost of registration. As it is today, we're still running the 1990 because we have not started operating the Cama 2020. As it is today, companies register, forgive my use of the word, share capital speculatively. They don't need the capital now. So they issue just a little. The law says, prescribes a minimum of 25%. So they meet that requirement. And then you have issue capital of the company. Now, what this has also done is that severally we've had to intervene in cases where directors allege fraudulent allotment of shares, people coming behind to give people they don't know, strangers, shares. And what we expect that this will do will be that, one, it will reduce the cost of registration by avoiding front-loading of costs. And then two, it will also reduce, it will support the small companies to register. So what you do now is, it's only the shares that you need at a particular time that you create. But all the shares you create must be allotted. They must be issued. So that is the difference. And the minimum, somebody asked, who prescribes the minimum? The minimum is prescribed by the Act. I believe that would be Section 26 of Section 27 of the Act, Cama 2020. Now, we also have an option for, as it is now, public users can register their companies directly. If you are a director, a first director, a first subscriber, you can register, or the business owner, you can register your businesses directly. But under the 1990 Act, you will still require a legal practitioner to play a role in that chain, in that process. Now, this new law has dispensed with that requirement. What it has done is to give an option. You can do it by yourself, in which case all you need to submit to the CAC is statement of compliance, not a statutory declaration of compliance by the legal practitioner, just a statement by the directors that everything that is required for the registration of this company has been complied with by way of documentation. But that notwithstanding, it's that you submit a statutory declaration of solvency. But if you are doing it directly on your own, you don't need that, just the declaration of compliance, statement of compliance. Then you have the optionality of common sale. Presently, every company is required to have a common sale, but this has been dispensed with. It's optional. You do not have to have a common sale, as it is now. And then we have electronic transfer of shares. So under the new implementations with the CAC. Under the 1990 Act and by regulation, you pay 10,000 naira, 1%, 10,000 naira for every million. But that has been reduced to an amount not exceeding 0.035 of the total value. Now, what that means is that when we're charging 10,000, we're charging not more than 3,500 naira per million. That is the ceiling. That means it can be reduced, it can be a lower amount, but that is the ceiling, it must not exceed that. Now, the small and one-man company are also exempted from the requirements of audit agent. Now, I need to clarify something here. We've heard it severally, said that private companies no longer require company secretaries. Private companies are no longer required to hold AGMs. Now, this is not the case. The truth is that it is not private companies, but small companies. We need to make a distinguish between a small company and private company. Now, a small company is a private company, but not all private companies are small companies. The definition, the conditions for some companies are identified clearly in the law. There are 5. They must not have government participation, must not have a foreigner participation. The turnover must not be more than, as it is in the law now in Cama 2020, 120 million naira or such other amount as may be set by the Commission. and the net asset must not exceed 60 million naira, or such other amount as may be set by the Commission. And the directors among themselves, I mean the subscribers among themselves, must take up at least 51% of the shares. Now, there are private companies that are larger in scope and whose turnover and net assets exceed this amount. So let us imagine a situation where we say First Bank, for instance, or EcoBank. These are private companies, but they are not small companies. Let us imagine a situation where we say First Bank or EcoBank should not have, or does not need to have, a company secretary. You know, so the intendment is not for private companies, but for small companies. And there is also the introduction of e-meetings for private companies. So private companies can now hold their meetings electronically. We know that this will mean cheaper cost of organizing these meetings, and it will also enhance participation. More people can participate from any location. So there's a higher level of shareholder participation. Now for public companies, in the public companies now, directorship is restricted to not more than 5. You cannot be a director in public companies or in more than 5 public companies. And the law has allowed the transition period for those who are holding directorship in more than 5 public companies to reduce that number to 5. And that will be within 2 years of the coming into effect of this new law. Now, what this does will be to promote, to reduce conflict of interest and to promote value addition. You know, it enhances their effectiveness in the management of companies. Now, public companies are also required now to display their audited accounts on their website. This is for corporate transparency. Furthermore, small companies that have been dormant from incorporation are also not required are exempted from audit requirements. Now, for us at the CAC, this will help us sanitize, clean up the content of documents that are submitted with annual returns. It will help us enhance the integrity. What we find today is because the law does not grant this exception, everybody's expected to submit audited accounts. People who have not been doing business just walk to any auditor who is willing, and they just cook up some figures and they stamp it and they bring it. Now, even a cursory look at the papers they submit, I'm not an accountant. A cursory look at the papers they submit, compare it with the form they fill, the annual returns form. There will be conflicts. Imagine somebody stating in the field for net asset, you stated 0 nil. And in the audited account you are attaching, you are saying amount in bank, 300,000 naira. How can you have an amount of 300,000 naira in the bank and that is not an asset? That is the property of the company, and yet you reported a nil asset. So with this exemption, companies are free, if you have not been doing business at all, if you are nil, just come submit a simple account. We don't need it audited. Then there's also the introduction of some of the new arrangements that have been introduced. We have company voluntary arrangements, which gives companies the opportunity, companies in distress, to initiate a composition of or scheme of arrangement in settlement of its debts. You know, it's even available when a company is in administration under wind down. Then you have what you call company administration. You know, this is also an alternative to receivership. These are business rescue mechanisms that have been introduced into the law. Now, the primary objective of a company administration, unlike a receivership, is to rescue the company. Rescue all of its undertaking, and if that's not possible, any part of its undertaking that can be rescued. In the present dispensation under Cama 1990, when a receiver is appointed, his primary duty is to his appointer. His whole concern is to recover the money that is that was advanced and then leave. So when he takes over the company, he's not bothered about how the company will fare after he leaves. So the process is actually hostile to the company. So that you find that mostly, particularly with the medium scale enterprises, once there's a receiver appointed, the prospect of that company bouncing back into business is always slim. But what you have under the new law is that the company administrator that is appointed, his primary objective, the first thing he must consider is to rescue the company. And another beautiful thing is that no matter how he's appointed, whether by debenture holder, whether by the court, whether by the company, he represents all the creditors equally. He represents all the creditors equally. Then we have the registration of companies at the instance of the company. Today, we can only register a company, what we call striking off, at the instance of the Commission. But what this has also brought into the playfield is to allow companies, there are prescriptions, I mean, basic requirements you must meet before you can qualify to apply under this head. You know, you can come and say, look, we're not in business. It's also an alternative to winding up. Winding up is an expensive venture. It's an expensive option for a company that has not been doing business and who wants to just go under quietly. Now, with the law also introduces what we call limited liability partnership. Somebody asked, how is this different from business, from companies as they exist? Now, the limited liability company is flexible. It combines the flexibility of partnership with the privileges of a body corporate under registration as a company. It's similar to company in arrangement and structure, but in regulation, it will be less regulated. So you can combine the flexibility of partnership, because it's still a partnership, with all the privileges of a corporate body. Now here you will have partners whose liabilities are limited, and you have partners whose liabilities are not limited. Now, for a limited, profit sharing will be as determined by your agreement. Now, for a limited liability partnership, you are required to have at least 2 designated partners. Now, these partners will play the role that directors play in companies. They will be responsible for statutory compliance or compliance issues. And in the case of penalties and assessment, accountability, they will be the ones that the regulator will hold responsible for compliance. Then you have the limited partnership. The limited partnership is similar to the business name. It does. We're talking partnership here. It does not suspend the regime of business names registration. Business names will still continue to exist. Now, in this limited partnership, you have partners whose involvement, who are sleeping partners. I mean, servant, and whether I can invest in private companies is not clear even under the code of conduct for public officers. What is clear is that I can invest in public companies, I can buy shares, I cannot be a director. But there's nothing clear about whether I can invest in a private company. You know, that's something we're looking to be cleared when the code of conduct for public officers is reviewed. But for the limited partners, I expect that funds from people like I should be available for businesses. I should be able to go into business with somebody, being a sleeping partner, and the person manages the whole business. We have an agreement that regulates how we share profit, but he's the one running the business. I'm not involved in any way. So we expect that it will also release some funds that are available for investment, but which are before this time cannot be accessed. Then briefly, okay, about public companies. Let's talk a little about public companies. It has also extended the preemptive rights of shareholders in the case of allotment of shares. It gives existing shareholders a preemptive right. So if you are going to allot new shares, first you must consider those who are existing before you take it out. Also, it now prohibits issuing shares at a discount. The reason for this is clear. We are trying to avoid the erosion of capital. It should not be encouraged that you should issue shares at a discount. Issuing shares at a premium is okay. That is a plus for the company. But when you issue shares at a discount, it's actually a minus, it's a loss. There's also a new clause, a new provision that allows a company to validate improperly issued shares. Under 1990 Act, if shares are improperly issued, your only recourse is to the court. But we are saying, no, it's an action by the company. Why can't the company address it? If the company can address it, why go to court? So now you find that the company should be allowed the opportunity to first validate. Where it refuses to do that, then the aggrieved person can go to court. We also have, strictly speaking, in the Act, in 1990 Act, a corporate body is now permitted to be appointed as a trustee to the venture, even though we see that happen. Now, what the law has done is to give legal backing to this practice that has been happening. If you go through the list of persons that can be appointed, you will not find the corporate body. But now we have included that in the list. It's what has been happening. It's what happens globally. So this is just to give legal backing to what happens. Now, companies may also now send notices of meetings by electronic address, electronic means. For any member that has provided an electronic email, an electronic address, companies can, in addition to the traditional means that we'll be using, post or physical addresses, you can also send by electronic means. I said earlier that it's restricted participation as directors in public companies to 5. It has also introduced for the audit committee financial literacy for all its members. And this is understandable. I mean, if we consider that what the audit committee is expected to come and review are financial transactions. So for every member, it is now compulsory that you must have financial literacy to understand what you are coming to do. Then lastly, let me mention that it has also introduced publication for unclaimed dividends. Under the 1990 Act, what you are required to do is to send a list of unclaimed dividends and the names of the persons entitled to your members. Now, ahead of the AGM, now what is required is not just to do that, but to also publish it in newspapers, national newspapers. So this makes it easier, makes it the chances of those persons who are entitled getting to know that they have this thing here is increased. Now, I need to quickly, I don't know how much time I have left, but I just want to address one or two things that I've been reading and some of the questions that came out here. Now, the first is what efforts, the first question is what efforts are we making as the Commission to ensure faster turnaround time for post-incorporation applications? Now, I understand, yes, I know, we also appreciate in the Commission that, yes, we're having issues, even before COVID, with service timelines. But I can assure you that the Registrar General is very, very concerned about this. And in the next few weeks, you will see an improvement. Because in the next few weeks, we hope to deploy some modules for treating post-incorporation applications online. In a few weeks from now, you will see that one or two of these processes will be done online. How does a single shareholder come from business? I think I addressed that already. Will the public or business community not perceive them in lesser light than companies with 2 or more shareholders? Again, let me say that the persons you do business with, whether they do business with you or not, will not be dependent on whether you have a single shareholder or one director. No, there are many other factors. I mean, the dynamics involves many other factors that they look at, including your performance or financial performance over the years. Again, the choice of registration is left to you. And don't forget that this is entry barrier, right? It is at the entry. What a one-man company, what we expect is that it will grow and grow bigger and expand and in the future, grow beyond a single shareholder company. That it will bring people in to expand even its own frontiers of business. Now, who determines the minimum share capital? I said that it's prescribed by law, is there. Now, has the CRP, that's the Company Registration Portal, been adjusted to accommodate these new entities, business entities? And how soon can applications for their registrations be submitted? Right now, we're working on them. What I can assure you is that the Commission is practically set to go forward on these new laws the moment it is gazetted. The forms are ready, the checklists have been prepared. We're working on the CRP now to accommodate these new entities, business entities. So soon as the law is gazetted, we can start to submit applications. Now, when will the e-solutions take effect? As we speak today, what we're even doing, what the Registrar General has instructed, that we're doing in the Commission is that I don't know if we all know now that certificates of registration for PRE is sent to customers by courier. Now, we have also instructed the courier companies, stop asking for the original documents. What we have, what has been submitted electronically is what we are working with. That's what we create as our hard copy, and that is what we issue as citizens. So that is the first step.
We're on injury time, sir. Sorry, sir, we are on injury time, 2 minutes
Okay,
more.
thank you very much. Thank you very much.
Thank
now,
you,
let me
sir.
quickly address, there's something I would have addressed, the consent thing, but maybe later bring for question and answers. Now, I've read 2 publications that that has described CAC as a monster in the light of the new law, and why those writers describe CAC as well. The writers believe that CAC can unilaterally decide to remove trustees of an incorporated trustee and appoint interim managers, or direct transfer of money in dormant accounts. Now, with due respect, I think the writers have misconceived the letters of the law. If you go to the new law, sections 839 and 842, they are clear that this power cannot be exercised without a court order. So, CAC can be a monster. Before you can remove direct trustees, you have, it says, in accordance with section 850, section 850 of that act prescribes how the CAC and any other person can petition the court for dissolution of an IT. CAC cannot on its own say this IT or declare or give the IT that this IT, this corporate trustee is dissolved. It must go to court. So we cannot do this without the order of the court. We need to clarify that. So please, when you see all such write-ups, take them with a pinch of salt, read through, and please take time also to go through the much of the new legislation that you can. Thank you very much.
Thank you very, very much, Mr. Tolulope Sonaike. You have dissected the Cama new provisions for us. You've told us that it has 5 objectives. Thank you. You told us there are over 200 new things introduced in Cama, and abolishment of authorized share capital. You mentioned that all shares must now be allotted. Again, you said we can just register statements of compliance, by directors. You don't have to have a common seal, and so on and so forth. And you've just capped it by answering some of the very controversial areas about removal of trustees. And you've said Cama will not turn into a hydra-headed monster, because there are provisions in sections, I think you mentioned 839, 832, and 850. And of course, there has to be a pronouncement by a court of law. We have really appreciated all this, and the questions are pouring into the chat box. In fact, right now, I am going to ask my partner CLB, Mr. Dapoyewumi, to probably allow us to extend this meeting by another 30 minutes, because I don't see us finishing up with all those questions just like that. But we probably will be answering some of the questions on the lips of people by calling in the next speaker. The next speaker has 18 years experience in enterprise development, non-profit management, strategy, and organizational transformation. She is currently the executive director at Faith Foundation, where she leads the organization and helps them to scale businesses through business incubation, growth and support accelerator programs, and they have impacted over 6,000 MSMEs across Nigeria, including my humble self. I am an alumna of Faith Foundation, and it is such a pleasure and a great privilege to have Mrs. Adenike Adeyemi to address us. I hope she has been unmuted, and right now she has the floor.
Okay, good afternoon, Mrs. Williams. Thank you very much to yourself, the CLB team, and the organizers of this conversation. I mean, if you look at, for a time when people are overwhelmed with webinars, and the fact that we have, I know at some point I was seeing messages around people wanting access and answering. On the Faith Foundation group, there's so many people asking, they want to be part of this conversation and asking for the alternate links. It just shows how important the conversation is, and why this conversation needs to happen. And for me, this really is the beginning of many conversations that the CAC has to have with Nigerian entrepreneurs, and hopefully also sets the standard for what we expect in terms of information, in terms of engagement, and in terms of really educating the citizenry with respect to laws. What is also happening again, which we can see in terms of the innovations of Cama 2020, is that there's a strong role on digital technology in that. And because of digital platforms and conversations like this, we can engage, we can ask questions with the regulators, which really we didn't have the opportunities to do before. So I'm very happy to be part of this conversation. I think my conversation really is the easiest because I'm also learning on this process and on this conversation. And very briefly, I think I have probably about 10 minutes, if not less. I've been asked to speak on, because I also want to give room for Q&As and clarifications. And I also have a few more questions and areas for consideration at the end. So once again, my name is Adenike Adeyemi, and I've been asked to speak very briefly on the importance of embracing and leveraging the new law, the Cama 2020 law, as I'll just call that in brief. Next slide, please. Yes. So thank you very much, Mr. Sonaike. I think that was a good background and in terms of the insights to the key provisions of the law. For me, from an entrepreneurial perspective and somebody who leads and supports businesses in Nigeria, it's that, you know, the law really reflects the new realities of running businesses and global best practices, which frankly, we should have implemented a long time. So for me, this is a long time coming, but could also not have come at a better time. One of the things that I think should be commended is really the stakeholder involvement and engagement and advocacy all through the process. And I think that a lot of times when we look at advocacy laws, one of the concerns really is that the target beneficiaries are not as engaged as they should be. And I think that this was one of those processes where, to a significant extent, there was a lot of engagement with SME bodies, SME BMOs. And one of the things that I think should be commended, like Mr. Sonaike mentioned, is the inclusion of the head of SMEs and NASME on the board of the CAC, because that means that there are representative groups that can speak for and on behalf of Nigerian SMEs there. Again, for me, is also that SMEs, in fact, micro, small, and medium enterprise organizations make 99% of businesses in Nigeria. So any law around company incorporation really has to focus on structuring itself around meeting the needs of Nigerian businesses and Nigerian SMEs who don't have large teams, do not have legal advisors, do not have chief legal officers, and who, like each and every one of the owner managers on this platform, are also understanding the law as it goes. A lot of us really don't have other people that will break it down to us in pieces, and it's important and it's commended that there's a lot of consideration on the law. And so one of the things I also wanted to point out again is that the emphasis on a small company, looking at a small company, which being one that has a turnover of not more than 120 million naira. Obviously, the Commission also has the right to fix the amount or the amount for that, and also one that is also with net asset value of not more than 60 million naira. One of the great things again is that, as Mr. Sonaike has talked about, is the obligations being eased now. So small companies are not obligated to hold AGMs or to have company secretaries. They may have one director. They are no longer mandated to appoint auditors at AGMs in terms of auditing their financial records. And I think, again, looking at it also reflecting the realities is also being able to e-file, do e-share transfers, do e-meetings. I know for quite a lot of our businesses at Faith Foundation that have had to do board meetings in the last 4 or 5 months. Most of them have had to do it virtually. And now, obviously, in line with the company's articles of association, the e-meetings can be conducted with that. And this is very critical for a lot of businesses rather, that are looking to enshrine leading corporate governance practices within their structures and also show a culture of transparency, accountability, and really what you want to see in a growing business. So the technological advancements for those are really important for Nigerian entrepreneurs to note. And then obviously the cost considerations for me, again, which is, my understanding is that the cost for total fees payable has been reduced to about 35%. So we're expecting about 65, the payment now for fees, for filings, should lead to about a 65% reduction. Again, we'll be watching to see how this is being implemented. Next slide, please. So one of the things I really wanted to really focus on was just the value proposition and why it's very important for SMEs and entrepreneurs to really consider that. Now, it's more than ever now, it's really easy to start up and set up a company. And that Nigeria was really one of the hardest countries to be able to do that. And that also significantly affected our doing business rankings. And so it's great to see that ease in setting up and starting up a company. Again, most of us are really the ones that are doing all of these things. And yes, quite a number of us engage lawyers in the process. But this new law really enables us to be able to do that. I think one of the other things, again, that is important is that separate entity concept, separating the individual and the company, and allowing each to run, and also reducing the risks on the individual and placing that responsibility on the corporate structure itself. The other thing, again, in the way we're functioning as businesses now is that most of us are operating locally, but we have a global reach. I'm sure at least half of the businesses on this platform have some form of the other of a web or digital presence. And what's happening now is that there's so many platforms. So there are quite a lot of platforms, whether Google My Business or even much more structured social media platforms where they're now requiring incorporation proof from your company's incorporation body to even be on it. So we should expect that for a lot of virtual platforms, a number of e-commerce platforms, particularly those that are global or international companies, will be requiring those proof around your company incorporation, your corporate incorporation, and also even your tax payment. So having this law that helps to make those things easier and much more flexible really is important for us to take advantage of. The other highlight, again, is those regulatory linkages. So the other day, a few weeks ago, we saw that now you get your CAC with your TIN number. So you don't have to go, when you're going to get this process, you know that that's one process that can run across several regulatory bodies. I know that's something that the Ease of Business Committee has been working on, and we hope that we get to see more of this with that. There are quite a lot of us that are also raising money. Some of us eventually are working towards listing on the stock exchange. And so in terms of seeking financing, investment, raising capital, this new law is also going to enhance that. Obviously, like we had also talked about, just even easing the corporate governance process, because it's one thing to advise. So Ms. Williams earlier spoke about wanting to set up a board meeting and really fulfilling just what one wants for a growing business and having structured board of directors and all of. But at some point, it just became legally unwieldy for small businesses to do. And one of the things that we can see now is that there's an ease with which you can run your meetings. You're not required to have a secretariat, and you can start to build your way and evolve your corporate governance structure to eventually adapt to what you want it to be. And then the last 2 points are around just even making it easier for structuring your business, building continuity, and then wrapping and exiting your business. I know there are quite a number of us too that eventually want to. So for instance, there are 2 examples. At this time, there is a number of businesses that have gotten to the point, particularly from the impact of the pandemic, where they want to wind up a business, or because maybe the business is no longer viable and there are concerns around the viability of the business. But what we've seen quite a lot is that people just leave the business, because by the time you think of all the regulatory requirements to wind up, to end the business, it is so cumbersome. And I think just even from a socioeconomic perspective, from recording numbers, data accountability, it's a problem. So you have quite a lot of dormant businesses where there really is not an end to it. And even for the country, I'm not sure that that's a good thing. So having an easier process in terms of business exit and business wrap up is really, really beneficial and important. So one of the things I want to say, next slide, is that for us, it's very important. It's a large law. It's the largest, I think if I look at any of the laws that I've looked at recently, it's really quite, next slide, please. It's really quite an intense law. And this conversation we're having, it's one of the many few that we need to have. It's important for us to almost be able to study, review, and engage the law. There are quite a lot of questions, and I think Mr. Sonaike, it will be important to let people know where they can also get the law, because it's not on the CAC website. And so it's important to make the clean copy. When will the clean copy be available? Where will it be? And so that people can start to engage with it and look at it. Sorry, can you move to the next slide, please? And then I think for all of us, because we have individual needs as businesses and as entrepreneurs, and so it's important for us to sit with legal advisors, because this workshops is not enough. It's frankly is not enough. And for some of us, there's some of us that are newer businesses, but some of us know that we really need to sit down, study and tease out the law, and understand what the implications is for our current structure and for our mid to long-term strategy. So an example is that, yes, there's a flexibility of not having
Yeah. Hello, everyone. I'm so sorry. It appears as if we lost Adenike Adeyemi, ED Faith Foundation. I'm sure she will rejoin shortly, but this is going to be an opportunity for us to start looking at some of the questions we have had. And I tell you, there have been numerous questions. So I am not sharing my screen, but I'll just read that out. And I would appreciate if Mr. Tolulope Sonaike can attempt some of these questions if they haven't already been answered in his presentation. Okay, so I'll just pick a few right now. Yes, so Mr. Sonaike, some people have said that unfortunately, a number of articles and summaries contain that inaccurate referencing, you know, this issue of private companies, small companies. So what do you think can be done about that?
That's rather unfortunate, and that is because different versions of the Act are circulating. Now, that was why I made that clarification. Most of those exemptions and indulgences are for small companies, not private companies.
All right.
Now, because, like I said, we must distinguish correctly between private companies and small companies. There are private companies whose operations are larger than what you call public companies. Yes, imagine a Pan-African bank like EcoBank, and you say it does not need a secretary or shouldn't hold AGM. I mean, that's ridiculous. No jurisdiction will ever legislate that kind of thing into law. So, and unfortunately, too, again, because I don't know, it's the document is highly controlled. As I speak, I'm not aware that at the CAC we have an officially communicated version. You see, what we are working with is the version that was sent to us to comment on, and we also understand that there was no change to it. So that is what we are working with, but no formal communication on the fact that this is the version that Mr. President has signed into law. That is why you cannot find it on our website or anywhere. You know, so it's, we still have to live with this reality until it is gazetted. Now, the purpose of gazette is to put everybody on the same page, and then the author will say, "This is the version that I signed," and that is why usually laws are not enforced. They don't come into operation. They are not applied until it is gazetted.
You are
because
right.
until that time, people have different versions.
That's just
until
what
the government
happened.
Will now say this is what I signed into law.
I was just going to draw a parallel between the recent Finance Act. You know, it was until it was gazetted. You know, so I guess you are right, and we need to really wait for the gazetted copy. I hope you can still hear me.
I can, madam.
All right. So, Mr. Tolulope, there's another question here that says, while many of the changes in Cama 2020 are commendable, the practical reality on ground does not seem to support the desire of CAC to ease doing business. Recently, the consent of Registrar is required before name search and reservation. Secondly, after incorporating a company, it is required that hard copies of incorporation documents be physically brought to CAC before original certificate of incorporation, the COI, can be collected. If these and others are still retained in the incorporation of companies, this person is saying the incorporation will be delayed. What is CAC doing to remove these bottlenecks?
Okay, I mentioned during my presentation that the RG, one of the very great concerns for the RG is this manual analog way of doing things, right? For him, and that is what we're doing now. I said it earlier that when courier companies, now your certificates are sent to you by courier, right, for registrations. Now, when they come, they are no longer required to collect your hard copy. We do everything with what you have submitted. We create your file because we must have hard copy backup. We create your file with what you have submitted. So as we speak, that has been somewhat dispensed with. Now, the issue of content. The RG is also not unaware of the reactions, you know, and people's opinion on the requirement to obtain consent before you can proceed to register. Consent for the name you want to use before you can proceed to register and incorporate trust. It's your right to register. Now, the reason behind it, and he has tried severally to also explain it, is that there has been a lot of concern for the seemingly unregulated sector. I mean, that the Part C is. Now, we also need to understand that Part C is not for business. Somebody says by what we are doing is not, in that regard, is not easy doing of business. It is not for business. It is for advancement of charity. It is forbidden that a corporate trustee should make profits for itself. So it is not for business. You don't even trade with that vehicle. Right. Now, the reason is that there has been so much focus, particularly concerned in the area of security. We have seen in this country several organizations that have come to register. And let's not also forget, we must admit this fact, that the regulatory capacity of the Commission is not so inadequate to the realities, to the demands of regulation in Nigeria.
All
that
right.
is the truth, whether we want to accept it or not.
Oh, no.
CAC,
Okay,
after registration, cannot go to every incorporated trustee, every church, every mosque, every NGO from time to time to say we want to know what you are doing. Okay. It is not possible. Even with companies, we are still struggling. So,
all right.
We're here.
All right, sir.
Some time back. Okay, is that enough? And is that enough explanation?
Yes, sir, because we still have so many questions. Let's quickly take one from Dr. Oresho Fekun. She says, is the process of converting from multiple directors to sole proprietorship limited company, sorry, let me get this. Is the process of converting from multiple directors to a sole proprietorship or to a partnership? You know, what is the process? She said, what is the process of converting from multiple directors to either A, sole proprietorship, B, limited company, or to a partnership, A, B, or C? Any changes in that process? Thank you.
There's no change. I guess the question would be, how does a company with multiple directors? But I think the emphasis there should be multiple shareholders.
Okay.
Because it's a single shareholder company can have 2 directors or 3 or more. So I think the emphasis should be on the single shareholder. So can a company with more than 1 shareholder become a single shareholder company? I believe that is the intendment of that question.
Is it, yes.
Okay. And then whether an LLP can become a company.
Okay.
I think that's the other leg.
Yes, and the qualification here is multiple shareholders, yes, which is what you were talking about. Yes. Whether we can have, you know, like a downsizing from the multi, to so,
okay.
yeah.
As long as it is a private company.
Okay.
It's important to know that. Because the single shareholder company only applies in the case of private companies.
Okay.
So that is doable.
Yes.
Now, whether an LLP can become a company,
okay,
right, it's still not so clear in the law. There's no direct provision for that. But I do not also think it is impossible. You know, if business names can convert and become companies.
All right. So this is where sometimes the businesses will need the advice of a legal practitioner. Yes. And Mrs. Adeyemi had said this, and if Mrs. Adeyemi is back, we'd like to hear her voice so that she can possibly conclude her presentation. We have numerous questions. Mr. Tolulope, we have another question here that says you spoke about filing fees being 1%. And the question from Nonso Ogini is 1% of what exactly? Turnover of the business or what? And I believe the business may not have started, so please clarify.
Now, I believe what I was talking about at that time was registration of charges. Now, charges are encumbrances you create on company property at the time of borrowing. So when the law requires that when the company borrows money, and secures its property as collateral for that borrowing, particulars of that borrowing must be registered with the Commission.
Okay.
Now, I was talking about the cost of registering it with the Commission. So that 1% to be the 1% of the total value of the borrowing that is covered by the charge on the company's property.
Yes.
So that has been reduced to 0.35%.
Okay.
Now, for the sake of knowledge, it's also important to know that a company may borrow a particular amount and secure its property for only a part of that amount. For instance, I can borrow 20 million and use other people's property to secure it, individuals, not companies.
Okay.
And the only portion of that borrowing that is covered by my company property will be 5 million. So the portion you are expected to register, to pay for, is that 5 million. So it will ordinarily be 1% of that 5 million. But that has now reduced to 0.35%, reduced by 65%.
Yes, you did say 3,500 per million. I remember.
Instead of 10,000 naira.
Okay. Mrs. Adeyemi
I am unmuted now,
back
yes.
with us. Okay, great.
Okay.
Please conclude.
So
Thank
just,
you, madam.
A few things, and I think that the questions we're having really was buttressing the point I was trying to make in terms of legal advice. It's very complex. And I think that one of the things that I'll advise the organizers to do is we really have to have working workshops to break this down further down. It's really too large for us to take in a whole. And while there are general provisions that apply across board, I'm seeing people asking questions about schools, charities, and all of that. In fact, even if you're doing it from a sectoral perspective or business stage perspective, we really need to have a workshop that takes people to a bit of the detail. For those who are much more matured business, we need to sit with our lawyers to say, what are the exact implications of this? Not just for the now, but for the future. So one of the things I would easily advise people not to do is to say, okay, because you are not obligated to have a company secretary or to hold or to have certain things or to do your audited statements, does not mean you should you should easily let go of it, because there are people who you're getting onto partnerships or funding that you're requiring who will require that just as a level of the type of business that you're in and a level of maturity, growth, accountability, and transparency. So while there are flexibilities in the law, you also have to look at it in the context of where your business is now and what you're planning for your business to be. And now say, okay, you can adjust to that. But that consideration is important. And then I think the last but not the least was what was now bothers around some of the questions that Mr. Sonaike is responding to. Again, the CAC has to take the lead on enlightenment and engagement. We knew that this was coming soon. So, and the fact that it's such a broad law means that people really need to also be engaged. And the CAC portal also has to be ready. For the last few months, quite a lot of entrepreneurs, even things like doing name search, you can't do. It's just not been available. And we've gone through, in fact, when somebody was complaining at some point, I now tried to do it myself. And I went through the app that you submit your issues to, and it was never followed through to the end. So as the CAC is expecting businesses to comply, or just even regulators in general, the platform also has to be ready for us. There has to be, otherwise people would not go through it as way to. So the technology readiness, the customer service, the processing timelines, and that reporting, how many businesses are registered. So once this comes into effect, the other question we need to know is that when does it come into effect? Is it now or is it immediate? And I think that needs to be clear as soon as the gazetted copy is also available. But there has to be that handshake between, if we're saying that we're innovating to be e-compliant and e-ready, then the platform has to be robust and sufficient enough. People should be able to send messages and their live chats on the CAC website to be able to do it. And that's what technology does. You don't have to, it's just getting the right people to be able to do that and really reducing, and now we're in COVID, there's social distancing and all of that, and that's really the frustrations that a lot of businesses are making. So I want to emphasize and sort of coalesce some of the issues that some of our businesses are having. Yes, it's a great law. It's well welcomed. It's appreciated, but that enlightenment and engagement has to be done very, very thoroughly. The technology readiness has to be there. The processing timelines for the platforms has to be there. The partnership with existing legal firms that support SMEs, particularly the small ones who are also here on this platform, who are also building that business, to ensure that there are also channels for that knowledge and reporting. And then the data, so we see how businesses are registering and what starts happening, and there's more transparency even in terms of just entrepreneurship and the ecosystem. Thank you very much.
Thank you very, very much, Mrs. Nike Adeyemi. She has dissected what the entrepreneurs are expecting to get from the new Cama 2020. She mentioned that even for Corporate Affairs Commission, because she had a bit of a dialogue with Mr. Tolulope Sonaike as well, the tech readiness, we really crave that, so that by the time we have the rollout, it will be seamless. We need that proper handshake, like she said, and she believes the platform needs to be made robust enough. We also need to know, when will this law come into effect? I was drawing a parallel with the recently promulgated Finance Act, and that was made effective February 2020. So we would really like to know, when this law will come into effect. As we go to the next round of questions, Mr. Tolulope Sonaike, can you give us a heads up as to when exactly this law will be coming into effect, while I prepare and cook up, or rather serve you with some of the other questions that have been put in the chat room? Yes, sir.
Okay, thank you. Thank you very much. Now, regarding the commencement of the Act, in lawmaking, the fact is that it's been signed into law. So as we speak today, we have a new Company and Administration Matters Act 2020. Now, signing into law is a different ballgame from implementation. Now, I said earlier, and I'm happy that Kikelomo also shared the same opinion, and he was able to provide some other insight with the Financial Act. Now, I said earlier that there are so many versions circulating now. We don't even have a version yet at the CAC. You see, we're working with what we had. So we're also working with what we're able to glean from the National Assembly. So if we are to start running exactly, I mean, which version does the public have? What do you know that is the law now, even though it's been signed into law? So that is why it is necessary that we will all just be patient. We're working on gazetting. It's not the responsibility of the Commission to do that by the Act, Presentation Act, Section 3 of that. It is actually the responsibility of the National Assembly to do that, to cause it to be published in the government pretense, Gazette, Federal Government Gazette. Now, we are working and trying to facilitate its early publication. And I believe that within the next few weeks, it should be published in the Gazette. It should be gazetted. Now, the moment it is gazetted, because at signing, Mr. President did not indicate any commencement date, from what I understand. What that means in law is that effective immediately. That immediately will now have to be interpreted in the context of this gazetting. So we at the CAC, we are preparing to start running with it immediately it is gazetted. That is the position of my Registrar General, my CEO, and the whole Commission is working round the clock to make sure that we are ready. Like I said earlier, the forms are ready, the processes and checklists are being put in place. By next week, there will be a management meeting to consider these checklists and procedures for the new entities and integrate it with what already exists. Thank you.
Thank you very much. I'm sorry, guys. I didn't know I was muted. So I have some good news for you. Our third speaker is getting ready. He's dusting all of his law books, and he will be jumping in the next few minutes. But we do have a question from the Nation newspapers, Daniel Eshet, and he's asking Mr. Sonaike about the classification of companies, micro enterprise, small, medium. How exactly should the companies be classified right now? Is there anything in the new law? He says micro entrepreneurs have been clamoring for reclassification of small business because of the disadvantages. How do you define micro, small, and medium-sized companies under the new law? This is Daniel Eshet, SMEs Desk of the Nation, Lagos. Mr. Sonaike, I hope we're not giving you a headache.
No, that's okay. That's okay. I mean, that's what I'm paid to.
I cannot join headache with it.
No, I'm paid to bear headache. I mean, headaches and all of that. So okay. that's the burden of the public servant. Okay. Now, on the types of companies that now exist, I think I saw that question, and then whether we categorize or classify the MSMEs. Now, for companies, nothing has changed in their classifications and types. The only thing that has been introduced is single shareholder company.
Okay.
Of course, there are new business entities that will be coming on board, the limited liability partnership and the limited partnership. right? But for companies, nothing has changed except for the introduction of the single shareholder company. Now, regarding classification of MSMEs, what we have in the Act, what the Act categorizes all of them as is small companies. And the conditions to qualify as small companies have been articulated clearly in the Act.
Okay.
The first of them is that it must not have any government participation. Another thing is that it must not have any alien participation. Then between the subscribers within themselves, they must take up at least 51% of the total share capital. In this case, that will not even be applicable because every issued share must now, every created shares must be issued now. So that will no longer be applicable. I think it's still in the law. That was an oversight. Now, another thing is that it must be a private company. And then two other conditions, we mentioned them earlier. The turnover, annual turnover threshold must not exceed 120 million naira. That's the threshold for turnover annual. And then the net asset annually must not also exceed 60 million. But those figures are rather high.
All right.
In fact, the Registrar General called me earlier and we discussed this also. I think one of the first few things that the Commission will try to address would be to fix a figure that is real. And then with the financial Finance Act, I think the figure there is 25 million. So CAC may be looking, because that provision allows CAC to fix any other amount as a threshold for turnover and net asset. So we may be looking to harmonize what we have in the Act, what we have in the Finance Act.
Okay.
I think the Registrar General is concerned about this.
About that.
Because if you leave it at 120 million and 60 million, that's very high.
All right. Thank you very much. Mrs. Adenike Adeyemi has jumped in the chat room to contribute to this discussion. And she says a company qualifies as a small company if it meets the following requirements. Number one, it's a private company. Two, its turnover is not more than 120 million, as you just mentioned, Mr. Sonaike, or such amount has been fixed by the Commission from time to time. You also mentioned that. Net asset value of not more than 60 million, or such amount as may be fixed by the Commission from time to time. In the case of a company having share capital, the directors between themselves hold at least 51% of its equity share capital. I think Mrs. Adenike Adeyemi helped to post that in the chat box just to clarify that point again. Thank you very much. And now I have some really good news for you. The other half of this partnership, that is Partners CLB and Center for Law and Business, have come onto the scene. And we have a speaker who has LLB, BL, PGD, Maritime Law. If I continue calling these certifications, we probably would not leave here today. So I am going to jump to the fact that he attended the then Obafemi Awolowo University, fondly referred to as Great Ife, but we do not want to start a war of universities on this platform this afternoon, so I shall say no more as an alumnus myself. Mr. Dapo Oyewumi, his early professional career was in merchant banking industry, where he served in notable banking institutions such as the Chase Merchant Bank, and he is currently engaged in training of professionals in the legal, finance, banking, corporate management, and related disciplines. Please join me in welcoming Mr. Dapo Oyewumi as he addresses us for just 15 minutes. Thank you, sir. You're welcome.
Thank you. Good afternoon, everyone. Apologies that I'm just coming on now. Sometimes technology gives us unexpected challenges in the most unexpected times and most unwanted times. That is what has happened, but I've managed to come in. I must thank Kike, our staff, in all the hoops and loops she went through to be able to get me back in. So thanks very much. I have missed quite a lot of what has been said, so I may or may not repeat some of what has been said already, but I will go on and then we'll see how it goes. I have a short presentation for you, which I will just share right away. Yep. Okay, I hope everybody can see my screen.
Yes, we can.
Okay, so we're looking at the Company and Allied Matters Act, and we're looking at under the considerations for small and medium businesses and enterprises. It's only natural that we should manage the context or determine the context upon which we're looking at this matter today, because of course the Act is very wide. It has over 53 chapters, about 7 parts, dealing with various issues. So it's not going to be possible to look at all of the issues. So for our purposes, given our audience, given our partners, Faith Foundation and all that, and Mrs. Fire as well, our connection with the Chamber of Commerce, the focus today is on small businesses and the considerations. And you just see, I said something, blessing or otherwise. It's nice to look at this and then we'll see how it goes. It's nice, usually I like to start with some preamble to give us a background of where we're coming from so we know where we're headed. So what I've done is to just give a brief history or origin of company law in Nigeria. And our starting point is when we gained independence in 1960. And according to the law at that time, every law of that is applicable in the United Kingdom as of 1900 became applicable in Nigeria. You can understand what the situation is at that time. Nigeria was a virgin country. There were no laws on a lot of issues. So it was going to be difficult to say, oh, build your laws as you go along. So we did a wholesale incorporation of all the laws that were applicable in the UK as of 1900 in 1960. And amongst those laws was the UK Companies Act of 1929. So as of 1960, we were using the UK Companies Act of 1929. Then they amended their law and did the UK Companies Act of 1948. And then in 1968, we created our first indigenous company law. I think it was under the military regime, so it was called the Companies Act 1968. And that remained until we had the Companies Act 1994, the Companies and Allied Matters Act, which was amended in 2004, and which has now been amended again this year, 2020, subject to when it becomes operational, as had been explained to us as Mr. Sonaike. So that tells us where we started from, how company law came into Nigeria. And then looking at that, would like to then look at some business formations. It's different types of forms of business so that we can understand how we can do business, because company and business is also. We have the one-man business. Under the new act, you will find the provisions for registration of a business name, as in sections 811 to 822, part E of the act. And the characteristics of small businesses, you all agree with me, or especially a one-man business, there's limited capital. The owner puts in all of the savings to start the business. Again, because of the limited capital, there are limited skills. He does all the business and he does all the running of the business. He's the managing director, he's the director, he's the sales clerk, he's the person who is marketing, he does everything. And then ownership and management are fused. He's the owner of the company and he's also the one managing the business. So they are fused. Of course, there's no separate legal personality. I will explain that. That means the one-man business and his business are one and the same. If anything happens to one, it happens to the other. There's no limited or that unlimited liability. God forbid, in the event of challenges, he will lose his share. Everything that is owned by him personally is also owned by the business. Then you have the partnership, which is a collaboration of 2 or more persons with a view to profit. And if you see there, we said the Partnership Act 1890. Remember, I had said all laws applicable in the UK as of 1900 became applicable in Nigeria as of 1960. So the Partnership Act of 1890 became part of the law of Nigeria. Interestingly, that law is still relevant today, although it has been amended in several instances. It's a matter that is under the concurrent legislative list, so some states do have their own legislation on it. For example, Lagos State has its own Partnership Act, which was amended in 2009. In fact, Lagos State had introduced this limited liability partnership in 2009 when it made its own amendments to the Act. And then, so we have the partnership. Again, partnership, 2 or 3 people, same thing, capital is limited, better than the one-man business, but not at the highest level. Skills too, you have 2 or 3 people who can put their skills together. Again, ownership and management is fused, and there's no separate legal personality and no unlimited liability. Then we have the limited liability partnership. Again, I've mentioned the Lagos State, and now under the Cama Act, under section 746 to 794, and then the limited partnership in 795 and 810. That tells us about partnerships, and well, there's a mention of foreign limited partnerships as well. That's a new introduction. Then the company, which is where we're headed. The name company suggests 2 or more persons. And it is believed that from the word and co, you know, Fire Williams and Co. SECL and Co, that the and Co that we have now become familiar with as Ashwebi actually started from this O and Co and Co and Co, because there's some uniformity and there are a group of people coming together to do a certain thing, and as such, the Anko that we're so familiar with, the Ankara Anko that everybody wears at parties, actually took its origin from this source. So for the company, there's better access to capital, better managerial skills relatively. I'm not saying it's total, but the tendencies are higher. There's a perceived better business reputational standing. Oh, I own a company, not that I own a one-man business. Oh, I'm chairman, I'm director of a company. It shows some better reputational standing. And I know in my banking days, in those days, because at that time, the movement to companies was still gradual. I remember that sometimes part of the conditions of granting a loan was to tell somebody to go and incorporate a company and transmute his one-man business into a limited liability company. Then there's separation of ownership and management. You have shareholders, you have directors who may be shareholders and who may not be shareholders. And in the running of the business, the directors are in charge of the running of the business and not the shareholders. So there's a bit of separation of ownership and management, unlike the one-man business where the owner is also the one running the business. Of course, company law, by virtue of company law, imposes or creates a separate legal personality. Once a company is incorporated, Mr. Sonaike will give you the authority that your company is separate from you. So you have a separate legal personality. The company will own assets in its own name. And those assets belong to the company and not to the shareholders of the company, talk less of the directors. And of course, there's limited liability. And what we mean by limited liability here is that in the event of any loss or the company run into insolvency, all the shareholders will lose is what they have contributed as their shareholding in the company or what they have committed to contribute. You know, there was a situation of paid up capital or called capital, which means capital that can be called when the company needs the money. So when you subscribe to shares on a company, you may not pay up all the shares because the company doesn't need it all at that time. But in the event of a challenge to the company, all that will be lost is the shares you have either paid up already or you are liable to pay up in the event of default. Yeah. And then consequence of incorporation. Once a company is incorporated, like I said, you get a separate legal personality of the company, which is evidenced by the certificate of incorporation that Mr. Sonaike will give us. Today, Mr. Sonaike is CAC for this purpose.
Yes,
So he's
yes.
going to be the one giving us all the certificates that we need. And I'm sure a lot of you would have heard of this case. It's a classical case on the separate legal personality, which is Salomon and Salomon. But I will not go into details as to that case. And of course, limited liability. Quickly, purpose of company law. What's the purpose of company law? What does it serve? There are two schools of thought. One is that it enables those who are in business to do their business. As I think I heard Mr. Sonaike when he started, that it's to the law, this law was established to attract investments, to ease the way of doing business, to make it easier for everybody to do business and all that. So that will fit this school of thought that company law's purpose is to facilitate and provide an enabling environment for people to do business, and it's hinged on the principle of freedom of contract. We all know that we use the common law system in Nigeria as it is in the UK, and one of the fundamental principles of common law is freedom of contract. There's another school of thought that says, oh, common law is regulatory. It imposes strong regulatory measures so that companies don't go overboard, or the shareholders don't go overboard, because especially for big companies, I mean, companies have been known to have sponsored coup d'etats in nations because a government that was not favorable to them was going to come into governance and things like that. So they said there's a need for companies to be regulated, and so that's the second purpose for which companies are. In my own view, I think it's a combination of both. Create an enabling environment for companies to thrive and also provide some regulation. The human nature needs to be regulated, otherwise there might be chaos in the land. And so that is said to be the purpose of company law. So a quick review of the Act. If I'm not wrong, it's structured into 7 parts, A to G, a total of about 53 chapters. Part A is the Commission. That's Mr. Sonaike represented here. And that's the regulatory part. It gives the powers to regulate the Act to the Commission in Part A. Then Part B talks about the company incorporation, functions, statutory requirements, annual general meetings, directors, transmission of shares, transfer of shares, and all that. A significant part of the Act remains unchanged. For example, annual general meetings still have to be held. The major change in respect of annual general meetings are small companies. And my understanding of small company, these things will unfold. It does not seem as if the small company is a permanent feature. So as we were told, if your your turnover is 120 million or less, yes. But the year you transmit beyond 120 million, you're no longer a small company. So the small company status is a moving status. You might be a small company today, but you may not necessarily be a small company tomorrow. So some of those benefits that we think have been created for small companies are temporary. Or if you want, if a company wants to continue to benefit from those exemptions, then it will strive to be a small company. And in my view, I'm not so sure that is our objective. Everybody wants to grow. I am 120 million today with 600 million assets. I want to move to 300 million turnover next year, and on and on and on and that. So, of course, you would then weigh the pros and the cons. Is it better for me to remain as a small company so I don't have to have an AGM, I don't have to have a company secretary, I don't have to have auditors? No, I don't have to meet the audit requirements. It's not that I don't have to have auditors. Those are the issues that we'll be looking at. And of course, there's a limited liability partnership in Part C. Part D deals with the limited partnership, then the business name, incorporate trustees, and the general provisions. So I want to look at a few notable amendments. I don't know what have been discussed. Like I said, I'm sorry, technology was just a challenge here. So I will go through, if we've already discussed it, then there's not much to debate about it. So there's a provision of a single member shareholder company under section 18.2. So one person can now become a company. If you look at it, it's contradictory. Company suggests 2 or more people, but now I can keep my own company. Well, perhaps it's a reflection of COVID, because with COVID, a lot of people had to keep their own company and stay by themselves and yet stay alive. So now you can have a company that is just owned by one person. Then we're no longer talking of authorized share capital. We're now talking of minimum share capital. It has changed. It's now 100,000 for private companies. It used to be 10,000. And 2 million for public companies. It used to be 500,000. Then there's a restriction on the sale of company assets. 50% of the company's assets now need the consent of all shareholders. Whether that is good or bad needs to be seen. But I know that there's something called the tyranny of the minority. So 90% of the shareholders want to sell their assets. A mere 2% or 1% don't want to sell, or they just want to hold the others to ransom and say, well, you have to convince me or induce me to want to sell. So sometimes it's a bit challenging when you do this absolute consent of everybody. You discover that the minority actually has a stronger hold there rather than the majority. So now that's that issue. Then the appointment of company secretary is now optional for small companies. You don't have to have a company secretary under section 330, but remember that I said the small company is not always a small company. It might be a small company today, might not be a small company tomorrow. So once you cease from being a small company, then you need to appoint a company secretary. And my position, which I'll talk later, is it's better for me to do now how I want to be tomorrow. So perhaps I should just appoint a company secretary from now on and then grow and all that, because it has its advantages. The definition of a small company is found in section 394. Again, both Mrs. Adeyemi and Mr. Sonaike have told us what those what the definition is. Small companies are also exempt from audit requirements in a particular financial year. So in the year that you are a small company, you don't have to meet the audit requirements. But once you become a big company the following year, then you have to meet the audit requirements. And from a business perspective, there will be a gap in your financials. If in 1 year you don't have audited accounts, and then the next year you have audited accounts, and the following year you have, again, should I just continue to have audited accounts? Again, now it's a matter of choice. It's not mandatory. It depends on where you want to position yourself and how you want to take your company into the future. Then a small company may have less than 2 directors. That's also a provision now. Normally, all companies must have at least 2 directors. Small companies, again, this year you're a small company, you have 1 director. Next year, you become a big company, you must have at least 2 directors. And then annual general meetings, I've already mentioned that. Small company may not hold an AGM in a particular year. And then for public companies, that had always been, this is just a reflection of corporate governance rules, absolute corporate governance rules, that you cannot be the chairman and be the CEO of a public company at the same time. And that's quite understandable. The rules concerning public companies are a lot more stringent than they are for private companies. And it's to be expected, because public companies raise money from the public. And as such, their duty of care, their fiduciary duty should be a lot higher than private companies where it's a few people who have come together to do their business the way they want to do it. So that happens there. Then disclosure of persons with significant control in the Companies Act. So if there's a company and you are having a significant control of the shares, then you need to disclose. That seems to me, I'm not very sure, seems to be a requirement more for public companies as well. Section 120 definitely makes a reference to public companies. And it stands to reason. If Fire and Co Limited Fire has 60% of that company, and her friends or her brothers and sisters, and me as her friend, she gives me 10%. I'm not really sure it's the business of any other person who owns the shares of the company. But of course, if it's a public company quoted on the stock exchange and the powers that such companies do wield, it is useful for the purpose of maintaining the integrity of the market and the confidence in the market that we know who own the shares of the company. The statement of compliance, that's when a company is being incorporated now. You just need a statement of compliance. It doesn't have to be sworn to or signed by a lawyer, as the case may be, but it's also subject to Section 42 because it gives the Commission, the CAC, Mr. Sonaike, the discretion whether or not to accept that statement of compliance. So it will seem to me that if they have reasons to believe that that statement of compliance is not correct, then it may be refused. But again, as the law is implemented, we'll see, because we can't really see the consequences of such refusal at this point in time and whether it can be resisted and all that. Common seal is no longer mandatory for companies, but then again, yes, you don't have to have a common seal these days. Everybody's used to having a seal. You fix it, and so you believe that the company, the document has been properly signed. Electronic filing, the law says under Section 860, everything that can be filed with the Corporate Affairs Commission can be filed electronically as well. And then under Section 176, there's a reference to electronic register of share transfer. All the documents that have been going around was talking about electronic instrument of share transfer. But on checking the act itself, what I saw there was electronic register of share transfer. Whether there's a devil's typo there, I honestly don't know, but that is what I have seen in the copy of the act that I have. Again, notable amendments, a limited partnership, it's a big issue now. So that's another type of business for people. The options now are that you can have a one-man business, you can have the general partnership, you can now have a limited liability partnership, which means a couple of members of that partnership have their liability limited. So in the event of the company having any challenges, they would lose only the investments in the company. That's what the limited liability partnership and the limited partnerships are making provisions for. And like I said, the Lagos State had already done something. Yes? Okay, you're warning me that my time is over. So Mr. Sonaike has graciously reduced how much we're going to be paying if we register charges. So if companies borrow money now, they know that the amount they pay for registration of charge is lower. Okay? So blessing or otherwise, after all said and done, all these amendments for small businesses, are they a blessing or are they not? I think it's a matter for debate. It's people's opinion, where they want to be and how they want to go. For example, a small company that has only one director and only one shareholder. That means all the decisions must be taken by him himself. He cannot consult somebody else. He cannot say, how do you think about this and all that and all that. and take a more informed decision. That's one issue there. Then bankers, no bank will lend money to any company that does not have financials or have audited accounts. So the Cama might say you don't need it, but does your business requirements need you to make it? Those are things. Growth, do you want to grow beyond a small company and become a big company? Succession, if it's just one man, one shareholder, one director, what happens for the future? What is the plan for retirement and all those kind of things? Best international practice, but all of that. So what the Act has done is to lay the minimum requirements, and I guess everybody would determine where they want to be in the scheme of things, and then they will go there. So I think I have managed to keep with the time on that note. It's time for question and answer. Well, I leave it in Mrs. Williams's hands to determine what next we need to do. Our very able moderator. Thank you very much. Thanks for listening to me. Yeah.
Thank you very much, Dr. Oyewumi. You have been excellent as usual, very erudite in your submissions. The greatest takeaway for me is that it's better for you to do now how you want to be tomorrow. And I believe Mrs. Adenike Adeyemi also corroborated this. You know, if you want to be a good corporate citizen, get your audited accounts in place, even though Cama says you can submit a simple accounts. Somebody has asked, can I submit management accounts? And that was Salako. And yes, you've been told you can't submit simple accounts. We had another question from BC Awoniyi, who would I have to give myself permission if I want to sell more than 50% of assets? And as Dr. Oyewumi has rightly told you, if you have only one person in the business, then you make all the decisions, but how good is that? So we have actually had a lot of questions, and the last comment I believe we may be able to take today is the one from Joel Orji. This is food for thought, Mr. Tolulope Sonaike. He is saying that he's suggesting rather that Cama and SITA need to align. So would you like to make a short comment on that? Or will that be taken back to the Registrar General? Okay, can we please unmute Mr. Tolulope Sonaike?
I think I'm muted already.
Okay, great.
I think I am. On the SITA and Cama harmonization, that of course is inevitable because somebody also asked whether limited liability partnerships will also be paying income tax. You know, the truth is yes, they will, because these are corporate bodies. You know, they are corporate creation of corporate. I mean, they now enjoy legal personality, and issues bordering on corporate personality is on the exclusive list anyway. So it's within the purview of FIRS. Okay. So yes, we may be seeing in the very short term amendments or review to the SITA to accommodate this new area. Right. And then, thank you, sir, Mr. Oyewumi. I see that most of the things, most of the issues there, you throw it back at the CAC to. Well, thanks for the opportunity. Well, electronic instrument of transfer is actually recognized under the new Act, and that will be seen in section 175, subsection 1. You know, and for those who are interested in, I usually don't like talking when we have lecturers. Mr. Oyewumi is obviously a lecturer, and I enjoy this presentation. Yes, because they know the history, they know where we're coming from, they know where we are, and they always have a view to where we're going. So when you start talking, they always help you find context. Please, do you know that this was what existed before? So because of that, I don't like talking where lecturers are. But most times I'm forced to talk before them. So when I talk very humbly, and I stand to be corrected. Right. So for those of you who are interested in the position of an incorporated entity, a company, its legal personality and privileges, you may look at section 42 of the Act.
All right. Thank you very much, Mr. Tolulope Sonaike, for representing the Registrar General at this event. And I would like to put my thanks towards Mrs. Adenike. Mrs. Adenike, so sorry, Adeyemi of Faith Foundation. I got that mixed up for a minute, apologies. We are now on the home stretch. We'll just take 5 minutes of your time. I would like to thank everybody who has stayed so long on this webinar. Dakoyumi, thank you very much for your presentation as well. You've been a worthy partner, a good friend of over 40 years. And from what I'm seeing today, this may turn into a series because it is obvious that we cannot exhaust all the questions at this one fell swoop. So we need to take this in bits. We have concentrated on entrepreneurs today. We have questions from someone like Nkoro Boniface, who is saying, what is the new position of unlimited companies and companies limited by shares? So we really need to look at other aspects, other company formations, and provide some light where there are gray areas. At this point in time, I would like to quickly share my screen and possibly sign off. I'll hand over to my colleague, Kike Lomo Obisheson. And we're almost there. We have thanked our speakers. And now I'll just like to say a little bit about Simply Exponential Consult. We are development, program design, and implementation specialists. This is what we love to do best, to organize various kinds of events and trainings. It's your ideal location for broadcasting your virtual events. I've been using fiber optic internet for quite some time now, and it's held up quite well. We have power backup as well. So we have workstations, we have training rooms, and you are very, 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 very welcome. Let me go on to the next slide quickly. Coming soon, we have online business management training for those who are worried about losing the money in the business in Nigeria. Nigeria is tough enough already. We don't want anyone to lose money. We'll be, so you just go to bit.ly/StartBizNigeria. This link will be sent to all participants who have registered for this event. And I am signing off. This is Fire Williams & Co. Limited, the new company opened by Mr. Dakoyewumi for me. I'm a virtual event moderator, certified master trainer. I help in skills acquisition, training of youth, and a business setup expert. You can contact us at 1A Aki Oshiemi Street off Allen Avenue, Ikeja, Lagos. All these details will be sent by email. And right now, I'd like to hand over to Kike Lomo Obisheson while I stop sharing my screen. Thank you. Okay.
Thank you very much, Mrs. Williams.
Yes, you're welcome.
I must say a very big thank you to everyone for staying with us from the beginning. We envisaged just 1 hour, 30 minutes, but apparently it's been a very, very robust conversation. Yes. And we've been privileged to have very, very versatile speakers. Particularly Mr. Tolulope Sonaike, I really thank you for your support and for your cooperation. It seemed like a daunting task, you know, just to get someone from Corporate Affairs Commission. We know how the bureaucracy can be, but you know, you gave us the opportunity and you came here to speak to us. We appreciate that. We also thank you, Mrs. Adeyemi. Thank you so much, Ma, for your time and for that beautiful presentation. And of course, I'll thank Mr. Dakoyewumi, who plays a double role. So is the lead partner at Partner CLB, which is a law firm and of course a sister law firm to Center for Law and Business that put together this webinar in conjunction with Simply Exponential Limited. We enjoy support from partner CLB barristers and solicitors. They give practical insights to some of the teachings that we do at CLB, especially law. So we really thank Mr. Oyeomi and the entire team at Partners CLB. In 3 minutes, I'll just run through what we do at Center for Law and Business, just in case that we have someone who is interested in any of our services. Center for Law and Business is like a one-stop shop, if you want to see it that way. It's an educational hub. We provide teaching support for a broad range of educational needs, from academic needs to professional needs, and even private tutoring. That's customized, private, confidential teaching in any area at all. Our academic products are anchored on the University of London undergraduate and postgraduate degrees, which avails opportunities to mature students who have family and work commitments, which will not otherwise allow them relocate abroad. They can study for the course with us, for their courses for undergraduate and postgraduate degrees with us at Center for Law and Business, and get the same certificates and the same quality of education from University of London. We also offer the International Foundation Program under the CLB Olumau International Foundation Program, which is in conjunction with IUFP, that's International Universities Foundation Programs. We do this is another very beautiful opportunity for young secondary school leavers who otherwise would have gone for their foundation year abroad, but who are unable to do so either because they're too young to be on their own and parents are worried, or they just want to stay home for the 1 year. And then even the COVID-19 pandemic also gives an opportunity for students who are uncertain or anxious about leaving home to actually take the 1 year foundation program with us and CLB and prepare themselves for admission into universities abroad. This makes them eligible for admission into several universities across 5 continents across the world. So it's a beautiful opportunity. And then we also offer teaching support for professional courses like ACCA, the Association of Chartered Certified Accountants, which is a global body for accountants, ICANN, CIPM, that's for HR practitioners, and many more. And we also organize training, seminars, and symposiums. Many people have signed up in our polls that they're happy to receive our newsletters and emails. So you're going to be receiving emails on some of our webinars. So our aim is actually to engender a better educated society. And that's one of the reasons that we put together this program in conjunction with Simply Exponential, just to ensure that at least the new Cama was signed into law on August 7, and then there's so many uncertainties and so many controversies. And we have even someone from CAC who is an authority on the statutes to come and enlighten the general public. So like Mrs. Fire Williams said, we might be having a part 2 coming up shortly, because this seminar was, although very robust, but it couldn't have been exhaustive. We couldn't have touched every area of Cama. I saw the bill, the new act myself was over 600 pages. And I thought, wow, this is not something we could do in 2 hours. So please look out for part 2. And these are some of our partners at CLB, GTU Student Services and Holmes Institute, under which we recruit students for UK universities, and also SOAS, University of London, University of Hertfordshire, and the IUFB. And a very interesting one that I think everyone would be happy to hear about is our partnership with Edfin Microfinance Bank. We offer access to world-class education, and irrespective of one's financial standing or status in the society, we think everybody should have access to very, very good quality education. And so we partner with Edfin Microfinance Bank that offers education loans to students who want to study, whether in Nigeria or abroad. And it doesn't matter whether it's an academic pursuit or even a professional qualification. Edfin Microfinance Bank with CLB will give you an education loan with a very, very low interest. I think about 2 or 3%, which is very, very fantastic. We are located in Lagos and Abuja. in Lagos at 18 Babatunde Jose Road, Victoria Island, and in Abuja at 92 Adetokunbo Ademola Crescent, Wuse Zone 2. You can follow us on our various social media platforms. You can send us an email at info@tlb.com.ng if you have any questions on any of the programs that we offer, and we'll be willing and available to respond to you. Thank you very, very much for your time. Thank you. This will be the end.
Thank you very much, Kikelomo Obisheson. She has been a great ally in the organization and implementation of this event. On behalf of partners CLB, Center for Law and Business, and Simply Exponential Consult Limited, I would like to say a big thank you once again to the speakers for today's event, Mr. Tolulope Sonaike, who represented the Registrar General, as well as to Mrs. Adenike Adeyemi, who held sway for all the entrepreneurs in the house, including myself. And of course, to Mr. Dapo Oyewumi, a worthy friend, a friend of over 40 years, who has been a great partner in educating the public on this recent Cama 2020 with all the provisions. And as Mr. Sonaike said, he's a great lecturer, as you can see. I think we're going to find a way to get him back into the ivory tower. To everyone who has stayed on this long, thank you very much. I do hope it has been time well spent. You will receive an email with more information, particularly for some of the details you asked for, the replay, the materials, how to watch the video again so that you can digest the new provisions. And as I always say, at the end of a great show, it's a wrap. And all I have to say now is vaya con Dios, which means go with God and have a beautiful weekend. Bye, and thank you once again to everybody. Bye-bye. Bye.